So thank you to everyone who stuck around. We are going to begin panel 2 in a couple of minutes. Before we do, I just want to make sure that I go over the CLE requirements again. So panel 2 is accredited for CLE. All of the information in the forms that you need for CLE purposes are available on the website, which I think Ellie will post on the chat. If you have any questions about CLE, please direct them to Diane Simmons, and I will post Diane's email in the chat as well. Just please be sure that when you, or if you email Diane, that you include the subject line Gene Conference. And as before, we invite participants to direct questions about the conference, to direct their Q&A to the Q&A button. And Karen will monitor that and be sure to put some of those questions to our esteemed group of panelists. And like before, and like with panel 3, please listen for the CLE code, which Karen will articulate at some point during the panel. So I am super happy to turn things over to Karen. This is going to be a great panel, I have no doubt. Thanks, Karen.
Great, thank you so much, Raymond. It is absolutely a pleasure to be with everyone. I hope folks were able to be part of the first panel, and you may be wondering, what is the relevance of Jean v. Nelson today? This panel is going to answer that tenfold. I'm really delighted to be with all of the panelists today. And what we're gonna do is, we're gonna start with opening remarks from each of the panelists, starting with Maryam, and then Oren, Sejal, and Mike. After they each give some opening remarks and focused on some of the litigation they've been working on under the Trump era and how it relates to centering race and equal protection and the legacy of Jean v. Nelson, then we're going to have some moderated panel discussion, and we will be monitoring your questions throughout and bring those in as well. So to kick us off, I would like to introduce Maryam Jordan. She is counsel for the Special Litigation Advocacy Project for the Lawyers Committee for Civil Rights under law. Through her work, Maryam supports legal and advocacy strategies in relation to cross-cutting racial justice issues, including defending the constitutional rights and dignity of Black immigrants, tackling environmental racism, challenging unfair city ordinances that disproportionately affect people of color, and safeguarding the First Amendment rights of peaceful protesters. She also represents Liberian nationals and 2 immigration organizations and African communities together versus Trump, which challenges the president's unconstitutional termination of the Deferred and Forced Departure Program for Liberian nationals. So Maryam, over to you to kick us off.
Thank you, Karen. Hi, everyone. So as Karen mentioned, I'll be discussing our litigation on behalf of Liberian immigrants who have been living under the country under a program called Deferred and Forced Departure, which is known as DED. But before I jump into that specifically, I think it'd be helpful to just reflect a bit on the situation of Black immigrants more broadly. I think this case is important because Black immigrants face a lot of challenges related to their intersecting identities of being both Black and immigrants in the United States. I think that they're not always part of some of the broader conversations about immigrant policies. And I think that it's very important to keep in mind, especially because Black immigrants face higher rates of criminalization. For example, the organization called Black Alliance for Just Immigration found that Black immigrants are more likely to be detained for criminal convictions compared to other immigrant populations, and they are more likely to be deported because of these convictions. And just because of these challenges that Black immigrants face in the immigration context, you've had organizations come together to advocate on behalf of Black immigrants, such as African Communities Together, the Undocu Black Network, and Black Alliance for Just Immigration. And moving on to our DED litigation, I think that from a racial justice perspective, the DED case is an important example of the intersection of race and immigration during the Trump administration, because this is the only this is an immigration program that only benefits Black immigrants. So DED is an interesting program. It's similar to another immigration program, which is known as temporary protected status, in which an immigrant is allowed to live in the United States and obtain work authorization, but DED is actually decided by a president's discretion. So when presidents grant foreign nationals DEDs, status, they do so under their power to conduct foreign affairs. But very important to keep in mind that DED is not a formal immigration status. So Liberians have been benefiting from the DED program for over 20 years. The first iteration came out in the 90s because of civil war in Liberia and has continued through the 2000s because of the Ebola virus outbreak. I would say overall about 4,000 Liberians have benefited from DED designations, and many have resided legally in the United States for over 20 years. And various presidents have supported DED across both political party lines. But not long after President Trump took office, he ordered the wind down of DED. And so in 2018, he directed the Department of Homeland Security to finish winding down DED by March of 2019. And the timing of this decision is very important because it relates to our central claim in the DED litigation, which relates to equal protection. So around the same time that President Trump ordered the wind down of DED, the administration was also winding down or starting to get rid of immigration programs that were benefiting immigrants of color, including TPS designations for various countries, including El Salvador. And around this time as well, President Trump made a long list of offensive statements about immigrants of color, including Black immigrants. Unfortunately, this has been a longstanding pattern since before his presidency, but I'm sure many of you are familiar with some of the, I think, more shocking statements, such as calling African countries S-hole nations and making insulting statements about Haitians and Nigerians. So just with this, all these different facts in mind, our organization, Lawyers Committee for Civil Rights Under Law and Lawyers for Civil Rights and a law firm, we filed a lawsuit in March 2019 against President Trump and the Department of Homeland Security on behalf of two Black immigrant organizations, African Communities Together and the Undocumented Black Network, and individual DED holders. We filed a lawsuit in Massachusetts, and we argued that the termination of DED was unconstitutional because the president decided to wind down the program due to his racial animus against Black immigrants. And I don't know if you all noticed, we filed the lawsuit the same month that DED was set to expire. And the reason why the timing wasn't, I guess, ideal or more would have been ideally filed earlier is the fact that there was a challenge with finding counsel for the case and the fact that this was legally difficult. DED is based on discretion, the discretion of a president versus a statute. And so from a redressability perspective or thinking about what kind of relief we could get for our clients, this was something that was always on the back of our mind. Can a judge order the president to extend DED? What does that look like? We eventually fashioned our case in which we believed that a judge could order the Department of Homeland Security not to implement the president's directive to wind down the DED program. And shortly after we filed our lawsuit in March 2019, we also filed a request for a preliminary injunction. And I believe an hour or two before we were supposed to have oral argument, President Trump issued a memorandum extending DED for another year. And so after that memorandum, DED was set to expire in March 2020. This was very, surprising, positive development. And even though our clients had at least another year to live in the United States legally, we moved forward with the case because we still believe that racial animus played a role in the president's decision to still wind down the program, even though he delayed it for another year. And eventually our case got dismissed because the judge found that we had an issue with redressability. He thought that to get a favorable outcome for our clients, he would have to order the president to extend DED, and he felt that was beyond his power as a judge. We disagreed. We believed that it was sufficient for the judge to order the Department of Homeland Security to prevent the wind down. And so we filed an appeal to the First Circuit. And while our appeal was pending, Congress passed the National Defense Authorization Act of 2020. And within that act, there was a provision called the Liberian Refugee Immigration Fairness Act. And this provision allows Liberian nationals who've been living in the United States since at least November 20th, 2014, to apply to become lawful permanent residents and eventually become citizens. And so this was a very historic moment. We believe that this is one of the first times that legislation has actually created permanent legal status for immigrants since the 1990s. And it's especially shocking that this happened during the Trump administration. But because of the Liberian Refugee Immigration Fairness Act, our clients and other DED holders now have the opportunity to apply for permanent residency in the United States. And even though our lawsuit didn't have a favorable outcome from a legal perspective, it is an example of how litigation can fit within broader advocacy on behalf of immigrants. We believe that our case helped play a role in creating pressure for lawmakers to do something to support Liberians who've been living for over 20 years, and forcing them to just remove their lives from the United States is, of course, extremely cruel and just against dignity. And so I'll leave it at that. But once again, we are, happy that there is a way for our clients to, be able to live in the United States permanently through the Liberian Refugee Immigration Fairness provision.
Thank you so much. Thank you, Maryam. That was really helpful. And we are next going to hear from Oren Nimni. Oren is a staff attorney at the Lawyers for Civil Rights, where he manages their immigrants' rights and criminal justice docket. His legal practice focuses on cutting-edge constitutional litigation on behalf of people of color and immigrants. He is currently litigating lawsuits to protect temporary protective status, deferred enforced departure, and medical deferred action. He is also litigating the first lawsuit filed in the country to block federal officials from conducting immigration arrests in state courthouses. His work in these groundbreaking cases has received significant national attention, and he employs a community lawyering model. And so I'm going to turn it over to Oren, who's going to give us a lay of the land on the important temporary protective status litigation. Thanks, Oren.
Thanks so much, Karen, and thanks for having me here. It's great to be on a panel with such wonderful, smart people who have been doing this litigation. So yeah, I'm gonna step back a little bit and talk about temporary protected status, TPS, as a program, and then talk a little bit about some of the litigation that's been going on in the country, including LCR's litigation, Centro Presente versus Trump, and some of the interesting things that come out of that when we're thinking about race and immigration and equal protection in kind of doing this civil rights, immigrants' rights type litigation. So as background, temporary protected status, TPS, is a humanitarian immigration program that is statutorily authorized but administered by the Department of Homeland Security. Essentially, previously the Attorney General, now the Secretary of the Department of Homeland Security, designates particular countries and nationals of particular countries as being protected by temporary protected status when there are conditions in their countries of origin that make it difficult for people to come back. So it's people that have been in the United States yet are unable to go back to their countries of origin because of civil unrest, environmental disasters, or other sorts of conditions that might make the country very difficult to go back to or uninhabitable even. And so a number of countries have TPS, but similar to DED and similar to DACA that Mike will talk about, the Trump administration sought to cancel temporary protected status wholesale for most of the countries that it had protected. This includes Sudan, Nicaragua, Nepal, and then Haiti, Honduras, and El Salvador primarily. And so what we were hearing on the ground from community organizations in Boston in particular was deep concern about the cancellation of temporary protected status. The people who have, the largest populations who have temporary protected status in the United States are immigrants from Haiti and from El Salvador, since hundreds of thousands of people have this status, and many people have been living here for over 10 years in the case of people from Haiti with temporary protected status, and sometimes, you know, up to 20 or 20 plus years if we're talking about El Salvador or Honduras. And so it's people that have been in the United States for a very long time, have developed deep connections, have built families, have gone to school, have built businesses and communities here. And so understandably, people were terrified by the prospect of TPS being canceled. Boston in particular has a very large Haitian community, I think third only to New York and to Florida, and also a very large Honduran and Salvadoran community. So it seemed natural for us to pair kind of the local organizing that was going on around immigrants' rights, around sanctuary city policies, around driver's licenses, and around resisting the incursions of the federal administration on these humanitarian programs. It seemed natural to pair that organizing with some kind of litigation to extend out the temporary protected status program. There was a question at the outset of who were going to be the plaintiffs and how this litigation was going to proceed, whether this litigation was only going to go forth on behalf of El Salvador, only on behalf of Haiti, or whether it was going to collect a bunch of the different countries and nationals who had been affected and pursue a case altogether. There are a number of different cases across the country that made different decisions along those lines and have all pursued on different tracks. LDF, in fact, I think had the first case that pursued relief on behalf of Haitians with temporary protected status. And so what we decided in Boston, because of the cross-cutting, the opportunity for cross-cutting organizing that it presented, was that we would file litigation on behalf of the immigrant groups that were most affected by the policy. And so that meant in Boston, temporary protected status recipients from Haiti, El Salvador, and Honduras. So we, much like the DED case, filed litigation on behalf of organizational plaintiffs and also individual plaintiffs. The organizational plaintiffs are Centro Presente, an immigrants' rights organizing group that works largely with immigrant communities from the Northern Triangle, including from El Salvador and Honduras, and also with Haitian Americans United, which works primarily with the Haitian American community in Boston and in greater New England. And so we filed with those organizations who were able really to spearhead a lot of the organizing and the legislative advocacy that was paired with the litigation. And then on behalf of a number of individuals who could really tell the story of what it meant to be in the United States for so long, to know that the conditions in their countries of origin were inhospitable and that they could not go back, and to really describe what it would mean if they were forced to go back, particularly on such short notice. And so the case wound its way through the district court in Massachusetts. One interesting note about Centro Presente as a case itself, and then I can speak a little bit broader about TPS litigation generally, is that it, I think, is the first district court case decided after Trump versus Hawaii. And so we brought, as part of our case, both Administrative Procedures Act claims and equal protection claims, but those equal protection claims were really open to challenge and open to attack when the government filed supplemental briefing on their motion to dismiss, saying, well, now, in light of Trump versus Hawaii, it's very clear that these sorts of decisions should be evaluated under rational basis scrutiny. And so in Centro Presente and in the rest of the TPS litigation across the country, there was a real challenge to how do you narrow Trump versus Hawaii to kind of the facts of the context there, narrow it to a national security concern, and try to keep that case as non-influential as possible. And luckily, the TPS cases have found success there. And I think that's partially because of how the TPS cases pled our equal protection claims, which I think goes to kind of, you know, the undergirding importance of those claims that we're trying to get at in this conference and in this panel, which is part of the goal in bringing the equal protection claims was, there were two goals. One is doctrinally, we felt that they were strong claims. There were a series of statements and actions that Maryam pointed out that really makes the Trump administration in particular open to equal protection challenges. And there have been previous cancellations of other programs or attempted cancellations like DACA that showed a kind of pattern of how they might enact a racially discriminatory animus against immigrants of color. But there's also a framing element that we and our community partners really wanted to highlight, which is this isn't just a case, even though these were some of our legal claims, this isn't just a case about an agency doing something improperly according to its own procedures. Yes, they didn't go through notice and comment, and yes, they made unexplained changes that are arbitrary and capricious, sure. But there's a broader framing element that we wanted to discuss about the racial logic that undergirds a lot of the American immigration system, and how that had existed for a long time, and how that was coming to bear with particularly brutal force in the cancellation of these programs. And so we made sure to discuss the history of the TPS programs, the back and forth between the United States government and the government of the countries of origin of the TPS holders, and how these immigration systems had really come to fruition and become open to this kind of abuse. And I think that was effectively able to pair a little bit classic civil rights or litigation, where you talk about kind of employment discrimination or voting rights discrimination, and immigrants' rights litigation, which feels like it's in a different field. But this was very much like, no, there is an undergirding racial logic that needs to be challenged here, and that's part of the framing that we want to get at. So right now, the TPS litigation is active all across the country. There's our case in Massachusetts. There are cases in New York and in Maryland and in California. The case in California, Ramos versus Nielsen, progressed on the fastest track, and they just had an unfortunate loss in the Ninth Circuit. But we're all kind of trying to see how these issues will percolate up through the courts, and also what kind of pressure that litigation can put on legislative advocacy to really push the movement for TPS extension and for hopefully a pathway to citizenship forward. So I'll leave it there and pass it on to Mike.
Thank you so much, Oren. And just one programming note, unfortunately, Sejal is not able to join the panel today. However, you are all very lucky because you can listen to the excellent podcast series for this conference that is on Spotify. She is in episode 5 and gives some of her reflection on the connectivity between law and organizing, and specifically her work on the TPS cases. So without further ado, I'm going to introduce our last panelist, Michael Richman, who is the William O. Douglas Clinical Professor of Law at Yale University. I am, however, going to refer to him as Mike. So Mike's scholarship involves a wide range of subjects and his teaching. He's focused on immigration, labor and employment, habeas corpus, civil rights, government transparency, veterans laws, and voting rights and democracy, just to name a few. He and his students have been recognized with numerous awards. I am going to pick and choose from a couple of his recent cases to share with you. They include Darwish versus Trump, which was the first challenge to the first Muslim ban, securing a nationwide injunction. Betaya versus Nielsen, which was the first nationwide challenge to Trump's attempt to end the DACA program, and is currently ongoing, challenging the latest round of attempts to gut DACA following the Supreme Court decision. Kennedy versus Fanning, which appointed the Yale Law School Clinic as counsel for a nationwide class of wrongly discharged post 9/11 Army veterans who suffer from PTSD or traumatic brain injuries. And NAACP versus Bureau of the Census, which was a challenge to the underfunding and design flaws of the 2020 census that would result in undercounts of African Americans. So I'm going to turn it over to Mike, who's going to talk about the Daca litigation, including its connectivity to equal protection and race law. Thanks, Mike.
Great. Thank you so much, Karen. And thank you to Raymond and all the many organizers at LDF and NYU for this conference. It's really terrific. As sad as I was that we couldn't do this in person, the first panel was great. The podcasts have been fantastic. I commend them to everyone listening if you haven't heard them already. And I'm really looking forward to the coming panels as well. And maybe when you guys organize the 36th anniversary of the Jean V. Nelson dissent, we can do it in person. So I want to try to do three things. First, share a few reflections on the work and the role of the equal protection claims and the race claims, really, in Battaglia Vidal and the Daca litigation. And it's a little funny for me to do that because Karen is co-counsel in that case and was the only other lawyer in America pretty much at the start who thought we should even be in court. Then lots came in, but Karen, I know, will step in and I hope share her reflections as well. Second, I want to think a little bit about equal protection claims more broadly in the immigrant rights movement and how, given all the challenges to those claims, they might still serve some purpose. And then finally, I want to end with a question and just a thought or two on that, which is in rereading Justice Marshall's dissent in Jean again for this conference, I found myself asking how one could imagine moving from what we might today call a non-racist or race-neutral approach to immigration, somewhat reflected in his dissent from the mid-'80s, to an anti-racist immigrant rights agenda that goes beyond race neutrality to affirmatively dismantle racist systems and structures, and what an anti-racist immigrant rights litigation agenda might look like. Okay, so first, equal protection in Battaglia Vidal. Battaglia Vidal is one of the Daca cases that went to the Supreme Court and continues to be litigated. The case started in a different format, and after Daca was terminated, we reconfigured it, and I would and included an equal protection claim, which was found by the district court to sufficiently state a claim so as to go forward, but which the Supreme Court, of course, concluded did not state a claim and therefore must be dismissed. In the opinion this year, from which Justice Sotomayor dissented, sort of a bookend to Justice Marshall's dissent in some ways, I think. So in thinking about whether to include an equal protection claim, I think it's fair to say that the students and lawyers who put the case together were well aware of the difficulties doctrinally and the many bars to fairly litigating race claims that the Supreme Court and other courts have built. Nevertheless, I think we saw important value in the claim. And I should say that it was a recognition that courts themselves are often nervous about intentional discrimination claims. And just as the majority opinion in Jean V. Nelson just declines to reach the equal protection claim, and just as the district court in the Guantanamo litigation that Ninaj Raul discussed in the prior panel, after trial ruled on, I don't know, half a dozen claims, and the one it declined to reach was the equal protection claim. So we were well aware that courts were nervous about equal protection claims and often don't want to reach them. We also recognized it was unlikely that if we failed on our APA claims, we would somehow win on the equal protection claims. It seemed unlikely that there would be judges who would say you lose on your APA claims, but on equal protection you win. Now, there was one judge in all of the cases on the Ninth Circuit who did exactly that, but we thought it was not likely that that would be the successful claim if everything else failed. Nevertheless, we included it, having determined, in our view, that there was a good faith basis to proceed, of course. So why did we do that? And looking back, was it worth it, given that it ultimately resulted in a Supreme Court slapping down an equal protection claim and making it more difficult, in all likelihood, for the next generation of cases to go forward? Why did we do that? Well, as I said, first, we thought we met the elements, and that our clients could fairly proceed on that. Second, we knew, and this is something I'll come back to, that APA claims, which many of us have litigated in the time of Trump, rarely permit discovery. And there is a large body of law that suggests that Administrative Procedure Act claims are most often decided simply on the administrative record. Now, there are important exceptions to that, but that is a thrust of APA claims. Direct constitutional claims, however, might open the door to important discovery that would be unavailable in mere APA claims. So there was a kind of lawyer's reason, a doctrinal reason, to potentially open the door to important discovery that might not be available if we litigated only under the APA. But more than that, and I think probably the primary reason, was that we fully recognized that the equal protection account of why the Trump administration had terminated DACA was the account that our clients understood to be true in the world, and it was the narrative that best encapsulated their own lived experiences. Our principal partner in this litigation, both our co-counsel and our client, and whose members were the individual plaintiffs in the case, has been Make the Road New York. And for all the protests that Make the Road and others have organized in the streets, I haven't seen a single sign calling for notice and comment rulemaking, or a better statement of reasons and bases for an agency decision. Of course not. That is simply not the understanding, I think, that I and most people have of why the Trump administration terminated DACA. And so if we were to limit the legal claims only to these more technical and proceduralist claims, that would ignore and in fact erase the account that our clients, their communities, and I think many people thought best described what was happening. So it was important to align the narrative of the case with the lived experience and analysis of our clients. And only the equal protection claim, truthfully, in my view, did that in the case. Now, it was the case that Judge Garifas allowed the case to go forward on the equal protection grounds. He denied the motion to dismiss. And just as Muzaffar Chishti in the last panel spoke about the importance to him of a single line from an early district court decision in the Florida litigation in the 80s, Judge Garifas in his decision, I think, kind of broke through the doctrine at one point. And after canvassing the Arlington Heights standard and discussing each of the factors and all the evidence, he wrapped up saying simply, while there are good reasons to tread lightly, the court does not see why it must or should bury its head in the sand when faced with overt expressions of prejudice. And that was a moment to my ear when the court simply cut through all the legal details, which it had carefully and appropriately canvassed, to say what we all knew and understood, that the court doesn't have to bury its head in the sand, even though equal protection doctrine may drive courts to try to do that. Well, the news after that wasn't as good for the equal protection claim. In the Supreme Court, the majority opinion by Chief Justice Roberts applied Arlington Heights in a cursory, perfunctory fashion, and concluded in applying the settled standard that the allegations were insufficient to allow the equal protection claim to proceed. And Justice Sotomayor, in the spirit of Justice Marshall's dissent in Jean, I think simply does a better job of canvassing the evidence and demonstrating why the termination of DACA likely why the allegations regarding the termination of DACA are well beyond the line to state a claim for relief. moving on, actually, sorry, one last thing, and to connect this to some of what Oren was just saying, I think it was, despite the essential loss of the equal protection claim, and not essential, we lost the equal protection claim. That's a bad thing that happened. I believe that in the Eastern District case, and Sejal Zoda certainly would have spoken about this if she were able to join us, that the district court judge there relied on the Battaglia Vidal equal protection analysis to enjoin the TPS termination on equal protection grounds. And while that's on appeal in the Second Circuit, there's no stay in effect. And so even though the Battaglia Vidal decision in the district court has been overturned by the Supreme Court, the TPS ruling out of the Eastern District, which remains the law, the injunction is still in place, is significantly based on the analysis that Judge Garifas undertook. That, of course, was not our purpose in including it, but it's a good reminder of the sometimes positive unintended consequences. It's impossible to know whether that was merely sort of window dressing in the opinion cited by the court in the Saget case, simply a helpful citation, or whether Judge Garifas's willingness to call it like he saw it in the Daca case emboldened or helped the judge in the TPS case to do the same thing and to grant an injunction based on the equal protection claim. Moving briefly to thinking about equal protection more broadly in the immigrant rights litigation world, and recognizing the difficulty of equal protection claims and the harshness of the doctrine, I nevertheless think there continues to be space for bold and creative work. I think that not enough immigration lawyers who spend most of their time in immigration court include express race discrimination claims in immigration court, in motions to suppress and in motions to terminate. As hard sledding as it is in federal court on those claims, immigration court is even more challenging. Nevertheless, that can be the essential framing, the honest narrative account of what has happened to clients. It can generate opportunities to seek discovery in immigration court and certainly appealable issues where warranted. And I think that immigration attorneys should continue to press equal protection claims directly in immigration court. At the same time, I think immigration attorneys could learn from the greater civil rights bar, as they have done increasingly in recent years, I think, and not limit immigration litigation strategies only to immigration court, but to go to federal court on habeas petitions, on damages actions, sometimes on FOIA cases, and on injunctive relief cases like the ones we're talking about now. Historically, many immigration lawyers were reluctant to go into federal court, and I think many civil rights lawyers were reluctant to enter the arcane world of immigration law. It felt too complicated, it felt like tax law. But I don't think that has well served immigrant communities, and so I'm encouraged to see more immigration lawyers expanding their toolkit and going into federal court, and more civil rights lawyers overcoming their nervousness about entering the immigration law space. Finally, just a word on thinking about what an anti-racist agenda might look like. It's one thing to think about an anti-racist set of immigration policies that might not only bring us to race-neutral policies and practices and procedures, but actually seek to engage in restoration and reparation that might require a number of measures, but it's very difficult to think about that in a litigation space. But that's part of what I think the immigration bar and the students on this call and advocates and academics and anyone should be thinking about as well, and whether it's possible through litigation to secure additional visas or permission to enter or to return for people who've been deported because they were singled out based on race in the deportation machine. To think about reparations, damages for families and communities that have lost members or been denied the opportunity to reunite with members abroad because of the pervasive race discrimination in immigration policies as well as practices. How to dismantle, not simply make race neutral, but actually dismantle the racist systems that define the immigration space seems to me the next challenge of this generation. Back to you, Karen.
Thank you all so much. That was incredible and so great to hear about all of your work. And I just have to say a hearty thank you to each of your legal teams for taking on these important and groundbreaking cases and cases that actually center and see race. So let's get to some discussion, and just a reminder that folks can put their questions in Q&A. We're going to start by just some moderated panel discussion. So each of you talked about your equal protection claims, but you talked about your other claims too. And the truth is, and honestly, I was surprised to learn that much like in John v. Nielsen, the Administrative Procedure Act has been doing the lion's share of the work in terms of challenging Trump's anti-immigrant and racist policies. So my question for each of the panelists is, what would it take to have a resurgence of equal protection claims, specifically discriminatory animus, in the immigration contest? What would it take for us to get past this reluctance that Mike talked about, that judges are reluctant to rule on equal protection? And I guess, to be a little more pointed, what do we need to have a reimagining of equal protection law so that we can not just bring claims that resonate with the lived experiences of our clients, but actually win them, maybe even past motion to dismiss stage? And I'll just say for myself, one thing that I have thought about is, well, is this a problem of how racism plays out by government actors today? Is it that, this ain't the racism of the 1960s where it's facially obvious? And I actually don't think that that's the problem, because my read of Arlington Heights is it's a multi-factor test. It gives us a lot of tools if judges were willing to go there with us. That is the long question. In short, what is it going to take to get to a place where we can reimagine equal protection law to win these claims in federal court? So over to the brilliant panel.
All right, I'll go first. That's a really loaded question there. I mean, I think part of my, reflection on this goes back to how we view race in this country. And I feel like a lot of judges, I think in part seem uncomfortable with tackling these equal protection claims. I think in part because how they view racism, and I think the attitude that things right now are not like how they were in the 60s. And I guess in terms of what would be needed, my first reaction is we need new judges, but being realistic with what we are dealing with right now, I think there needs to be a broader cultural and educational shift in terms of how we view racism and how it permeates various aspects of the government. Because just going back to the Arlington Heights factors, I feel like at least in the cases we've been discussing today, we have examples of pretty horrible racist statements from President Trump. And so I think that this should be a text case example for what would be needed to prove an equal protection violation. But I think, unfortunately, just dealing with the hesitancy from the judges has been a big obstacle. I mean, I will say that for the DED lawsuit in particular, that wasn't actually the big challenge that we had. I think that the judge seemed to agree with the president having racial animus. It was do more to what he could do about it and how to hold the president accountable. And so I think that should also be part of the conversation. At what point do we let the president get away with instilling these racist policies in the immigration space, and I guess just in other types of policies in the administration?
Thank you so much. Anything to add, Mike and Oren?
I'll just say briefly, just to echo some of Maryam's points, I think that in some sense, this conversation perhaps can't progress without serious court reform, just because I think if you look at recent decisions out of the circuit courts or out of the Supreme Court, there's a pretty clear indication that even the discussion of race, let alone the discussion of intentional discrimination on behalf of the government rather than on behalf of, like private actors like employment or perhaps in housing where they're more used to maybe dealing with it seems a little bit off limits. It's also a difficult thing because there is a kind of white supremacist underlying logic to the immigration system as a whole. And there's a little bit of a question of, well, do you challenge, very particular elements of it as particularly egregious, or is there some sort of undergirding change that needs to happen? That said, I think that there's two possibilities in this current moment. One is we also in Centro Presente surprisingly didn't have a problem with convincing the judge that to accept our equal protection claims. And I think part of what we did there was really bringing to bear the history of the programs and the way that they had been disparately also experienced by different racial groups. So I think that there's some storytelling to be done. I think part of the other thing is redefining a little bit how we think of victory, and I think we've all sort of spoken about this a little bit, but that equal protection claims do two things. One, they are doctrinally sound, and I think getting judges to understand the real play in the joints that they have to evaluate these elements under the Arlington Heights standard is useful. But as Maryam highlighted, the claims in the end of African communities together versus Trump didn't succeed if we think about success as victory in litigation. But they did succeed in the sense of, well, the communities that were fighting for the ability to stay in this country and to not be separated from their families have won that fight. And I think that's in no small part to a real reckoning with how this program and how the Trump administration and how African immigrants in general have all been treated in this particular moment. And so that kind of framing and advocacy element is also, I think, important as we think of litigation as one tool amongst many.
I'll just add one comment briefly because it hasn't been touched on yet. One of the things I have been wondering about is whether, so first of all, I think no matter how bad the doctrine or how unsympathetic the judges seem, I think the power of litigation is ultimately in the storytelling and the narratives that it conveys, and that there is a power in that and a utility in telling stories even to a hostile audience. I think the audience is not unaffected by the stories it hears, even if in a given case it rules against one. But what I wanted to raise was the role of arguments about implicit or unconscious bias and how those might factor into equal protection arguments, whether there's and we have not done this particularly in our cases. I'm not speaking only of the Daca case, but other immigration cases where we've raised equal protection claims. To the extent we recognize that judges are afraid of race claims and afraid of equal protection claims, it makes them nervous. They don't want to reach the issue. Is there a way to make understandings, modern understandings of unconscious bias a more explicit part of the story we tell, such that a judge might feel that they could hold a policy or a discrete arrest or deportation action or criminal conviction underlying a deportation proceeding to have been the product of impermissible race-based bias without quite saying it was intentional because it was implicit or subconscious? Does that sort of let the judge off the hook of having to look someone in the eye and say you were intentionally a racist while nevertheless granting relief on equal protection grounds? And I'm not sure how to use the learnings of the last period of years in telling equal protection race stories, but there may be some opportunity there even for judges who are hostile.
Thank you each so much. It's so helpful and so much in terms of inspiration for what we can do in the future. So I want to ask any of you who want to comment on this question, which is, can you describe a key moment in your litigation where something happened? You were deposing a key official, you got documents, you got an admission, you learned something new where you said, this is it, right? This shows that what we have here is a racist policy, or at least you felt like you had a story to tell, that the motivating factor here was racial animus, and it was because of something you uncovered or a moment that happened in your litigation. So we'd love to know what that was, and if you think you were able to use that moment to tell the story either to the judge or the broader public that what was going on here was not just cruelty by the Trump administration, but actually racial discrimination.
Can I throw that back to you, Karen, and ask you to say anything about the Hamilton deposition you want to share?
Oh, well, that was one of our moments. I can do it briefly while others think. The story of this, particularly for any young lawyers or law students listening, is to remember that your young members on the team sometimes make all the difference. And we had an attorney who was young in lawyer years, who, when we thought to ourselves, well, we want to do some depositions, we're not sure what we should do, came up with the idea that we should depose a man named Gene Hamilton, who at the time was a little bit unknown. But basically, he had done some research and he said he shows up everywhere and he's an acolyte of Jeff Sessions, and I really think he might be behind this all. And the short version of this deposition, which was much more dramatic than we wanted it to be, because we got to stay on discovery in the middle of it, halting the deposition before I got to all the equal protection questions. But before we got there, it was evident that to me and to our clients who had wanted to be in the deposition, that number one, we learned that this was the person who wrote the memo terminating Daca. Really took credit for when I asked him that on a bit of a whim. But number two, I wasn't trying to get any reactions when I asked him the following set of questions. I was trying to lay foundation of knowledge. I asked him if he thought the policy change, the memo he wrote, terminating the program, was a significant policy change. That's it. I was just trying to lay the groundwork for the fact that they should have taken into account reliance interests, or maybe should have done notice and comment. Totally mundane APA questions. And he really started to fight with me, and in a way that made my skin crawl and our DACA plaintiffs' skin crawl. And he ultimately said, in a back and forth, when I was just trying to get him to admit that a policy change affecting over 800,000 people was significant, he ultimately said something to the effect of, well, no one's going to die, and it's not like these people were entitled to anything. And that's when I knew there was racist intent going on. So, Mike, I hope that was the one you had in mind. Goodness knows there were plenty of makes your skin crawl moments during our discovery work.
Well, I know you had. I know you've had many things to say along the way, and I wanted to make sure you got into the conversation, Karen, instead of just posing questions generously to the rest of us.
Others, Oren or Maryam, anything from your cases or moments when you thought, oh, maybe this is it. This is how we tell the story of the role of race here.
I mean, I think for us, one of the stories that we wanted to tell was how close in time the comments were made about African countries and Haiti and all these immigration decisions, how close in time they really were, and discovering through some of our own discovery and some of the discovery done by other TPS teams, really just that essentially some of these things, some of these statements were not just around the same time, but we're actually in meetings describing the TPS program and sometimes other immigration programs as well. And so there's a document that came out, I think, of the Ramos litigation about the previous acting secretary determining whether or not TPS would be canceled for particular countries. And that essentially one of the documents says that it looks like someone came up behind her, clubbed her on the head, dragged her away, then typed a new memo saying that actually it should be canceled because all of the previous logic led to the conclusion that it shouldn't. And so I think we went in because of our analysis and because of the analysis of our clients, we went in knowing that this was a racist decision-making process. But I think some of the things that we uncovered, and also in deposing people like Gene Hamilton, that we uncovered throughout the process made it very clear not just how racist the program was, the decision-making was, but how much it suffused the administration and how directly linked it was to the massive changes in immigration policy that were ongoing.
And I'll just add that even though we didn't make it to discovery, I think that the TPS litigation helped pave the way for us to really think about how to frame our equal protection arguments. Because by the time we filed our complaint, there had already been favorable opinions, I guess for the lower court in Ramos, from Centro Presente and Sage, in which we were able to, I guess, just cite to other courts recognizing the role of racial animus in the TPS cancellations, and how we could even make an even stronger argument for DED because the president himself made the decision to wind down the program. And so I think similar to what Oren and his co-counsel dealt with, I think for us too, just thinking about the timing of the presidential memorandum that ordered the wind down of DED, and how when that came out, soon after the cancellation of TPS, soon after multiple racist statements against immigrants of color, including African immigrants, and just how that helps tell a narrative of how racism played a role in the termination of DED.
Karen, if I can just give one example as well, though it's not from the Daca litigation, but it's to my earlier point about the importance of, I think, immigration lawyers bringing a civil rights orientation and spirit to deportation defense. Some years ago now, the city of New Haven became the first city in the nation to offer a resident ID card to all residents, regardless of immigration status, a program that's now taken root in many places. And in retaliation for the city of New Haven offering this optional ID card to all residents, ICE conducted the largest raids in the history of the city, we think in the history of the state. And the clinic in which I teach came to represent people who were arrested in that raid. And all the cases have been resolved. It's been many years, but one, which reached the Second Circuit last year. And the Second Circuit found that our client had made out a prima facie case that he had been singled out and arrested during these ICE raids based on race. And on that basis, granted his petition for review and remanded to the BIA. And it relied significantly on evidence that we had developed outside of the deportation proceedings through state FOIA litigation, federal FOIA litigation, a federal civil rights damages case that others arrested brought that this client chose not to participate in. And I just want to read one of the emails that the Second Circuit came back to a couple of times that we got on FOIA. We could not have gotten through the immigration proceedings alone, in which the lead ICE trial attorney in Hartford, a couple days after a lot of local press about the municipal ID card, emailed to his colleagues, Yale is loading up the Amistad with illegal aliens and sailing them to freedom while John Marley openly weeps. And that was why they needed to stop the ID card. I don't know why. I can't begin to unpack that statement in all of its depth, but somehow associating the effort of immigrant communities in New Haven to secure full citizenship and participation in society was associated with a struggle for Black liberation, and that was a bad thing somehow to him. But that was a stunning moment when we saw the ICE attorney, not even the agents, the lead attorney for ICE in the state, talking explicitly in those terms. And as I said, that's memorialized now, and part of the evidence the Second Circuit looked to in concluding that there was a prima facie case that this was an arrest based on race, and for that reason impermissible, even under the unforgiving standards of race claims in deportation proceedings.
Thank you so much for that addition, Mike, and for all of you. This is just a plug for why one should love discovery and what it can get you. I want to do two important things now. First, the CLE code for all of you who want to get your CLE in. It is the color purple. So that's what you need for this panel is purple. And now we're going to shift to some questions that are coming from the audience. Thank you so much for these great questions. The first one is from Kila Espinosa, who asks, what community lawyering tools are informing how you approach this impact litigation? So anyone who would like to jump in on that?
I can start, and then I'm sure other folks have good things to say on this as well. But at least for LCR's immigrants' rights docket, we try to have all of our cases informed by a community lawyering or movement lawyering approach. What that means pre-litigation on the front end, I think, is just as important as what it means during and post-litigation. On the front end, it means that a lot of our work is just going to community meetings and kind of understanding from people what things are difficult, what problems they're seeing, and then discussing with the community organizations that we work with whether we think and whether they think litigation would be a viable tool to solving some of these problems, or whether litigation is actually not the best tool to doing that. And so for the TPS case, it started very similarly. We have good relationships with both of the organizational plaintiffs that were lead plaintiffs in the case, Centro Presente and Haitian Americans United. And we obviously knew that the TPS cancellations were coming down the pike from announcements in the Federal Register and from indications from DHS. But it was really our clients and the community organizations who identified this as, first of all, a very major and important thing for all of their lives, and second, a thing where litigation might pair well with the community organizing efforts of legislative advocacy that they were already engaged in. And particularly for Centro Presente, that it would also lend support to some of the cross-cutting organizing that the Haitian community and the Salvadoran community were trying to mobilize and to build. And so that was sort of the genesis of Centro Presente. And then from there, it's still an iterative process back and forth between us and our community organizations about, what path we want to take, how we want the arguments to be framed, so that we're really encapsulating all of the stories that they're bringing to bear and all of the ends that they want met through the litigation and through other advocacy. And then in particular for the Centro Presente case, we also tried to engage in community lawyering, not just within the United States, but outside of the United States, and took a number of trips to El Salvador and to Honduras to meet with community organizations in those countries where we could learn basically about, what struggles they were facing. We met with this women's rights organization in Honduras that talked about the extremely high rate of femicide in the country, and we were able to share those stories and bring them in through affidavits and declarations to say, look, these are struggles that people are facing kind of across countries, but also very clear reasons why people shouldn't be forced to go back because of the cancellation of this program. And so really the litigation was driven kind of from start to middle by community organizations. And I think that's led, along with all the other TPS litigation and all of the great work that community advocates are doing, to TPS being more forefront in the national conversation. I think, a couple of years ago even, I think DACA was fairly well known as an immigration program, but TPS not so much, and DED definitely not at all. And I think one thing that litigation can be useful as far as a tool paired with legislative advocacy and organizing is really catapulting an issue into the fore and into the national media and putting good pressure. And so, since that date, TPS and then DED have been tacked on to some of the legislation that's been pushed for legal permanent resident status for DACA recipients.
That's great. Let me do one thing, just because we got a bunch of great questions in the chat. Let me read a couple of them at once, and then it'll be like a panelist smorgasbord. You all can pick and choose which ones you want to answer, but I want to be able to really pull in the great questions from the audience. So let me bring up a couple on screen, please. So first is a question from Naomi Sue, who thanks everyone for the work that we're doing and wanted to follow up on Mike's fabulous challenge to think about anti-racist litigation efforts and remedies. What anti-racist litigation remedies and efforts would other panelists like to see? Okay, so that's question one from Naomi. Let me pull up question two from Rex Chen, who writes, one long-term goal is to help the public understand how racism exists today. The public does not read the legal filings. Do you have tips on how your teams and community organizers can raise this? Maybe it's in press releases or opinion pieces. What do you think has been most effective? So why don't we get any panel input on those questions from Naomi and Rex?
I'll take a crack at answering Rex's question. So, I think Rex's suggestions are definitely on point. I mean, even though we are filing these cases, we cannot forget the court of public opinion, which plays a huge role in helping advocacy get accomplished. And so I'm actually going to build off of some of the points that Oren mentioned when it came to the community lawyering approach. At the Lawyers Committee for my project as well, we strongly believe in having our work as community centered as possible. And for the DED case, we really tried to take the lead from our organizational plaintiffs and our individual plaintiffs. And the way we even got involved in the case, we were approached by undocumented Black and African communities together about filing a DED lawsuit. And so by the time we were already contacted by our future organizational plaintiffs, the broader Liberian community had already expressed interest in pursuing litigation in addition to legislative advocacy. And so while we were developing the case and after we filed the lawsuit, we also try to push for other forms of advocacy and really trying to get the narrative out there, just because I think that the experiences of DED holders is very compelling. And, when you think about the fact that many have been living in the United States for over 20 years, that they've established livelihoods here, that many of them have US citizen children, the risk of them being separated from their families, from their children if they had to return to Liberia. And also the fact that Liberian law doesn't necessarily allow dual citizenship, and what that meant for children, US citizen children of Liberian DED holders who, if they had decided to go to Liberia with their family. And so, those are just, some of, the important facts of the narrative. And while we were, engaged in litigation, some of our organization, or some of our individual plaintiffs released op-eds, including our plaintiff, Yata Kiazulu, who is currently pursuing her PhD at UCLA. Some of them testified in front of Congress explaining, their own stories and what the termination of DED would mean. Organizational plaintiffs helped organize rallies and other public demonstrations. And so, by supporting these efforts, I think we were able to help raise the profile of what was at stake for DED holders, and just helps inform the public on what was going on.
These are such great questions, and of course I want to hear what Naomi thinks about her question and what Rex thinks about his, and for all of them in the chat that Karen didn't get to. I wanted to say on the community lawyering point, which also goes to Rex's question about public advocacy, I think that if the goal is not the litigation win alone, but if the goal of the work we are doing is to build power in communities, to bring about fundamental change in power and wealth in this country and its systems, then litigation is no more than a tool. And really it's a tool that I think should be surrendered to the extent possible to impacted communities. And by that, I mean, what we do as lawyers should be determined not by the lawyers themselves, but by impacted communities, deploying lawyers as a scarce resource like any other. And then once we launch litigation, I think the community needs to remain somewhat in control. And the law is not always set up. The rules of professional responsibility are not always structured with community lawyering in mind. But there are important ways that I think lawyers can surrender some control, not only over the initial decision, should we go forward or not with lawsuits, but once they're begun. So for instance, one can invite community-based organizations that have been working on an issue or working to protect a group of people, not only to identify a plaintiff to launch a lawsuit or maybe themselves to be an organizational plaintiff, but if they have any lawyers on staff to co-counsel the case, which is something we did in Battaglia Vidal with Make the Road New York, which at that time was not particularly engaged in federal litigation or structural litigation, but had lawyers who on staff. And so we invited the organization to be a plaintiff, meaning now they became our boss, and to be co-counsel, meaning that they were privy to, there was never a moment where the lawyers weren't talking with the community group, because the community group that led the fight and has led the fight was the lawyers. There was a sort of a unity there. And that can be, for lawyers who are accustomed to driving the bus, surrendering control, both at intake and along the way, can feel difficult. But I think that's an important aspect of litigating for social change if we're serious about building power in subordinated communities. On the remedies, I just, in a couple of words, Naomi, I really would love to hear what you think about that as well. But the kinds of things that occur to me is, to the extent we believe that the racism that pervades the immigration system has led to, for instance, anti-Black racism in immigration law, and therefore to disproportionate deportations of Black immigrants, to disproportionate denials of visa applications for any purpose of Black immigrants, then there should be some kind of diversity visa lottery or something for certain targeted communities. We began today talking about Haitians. So Haitians certainly have been disproportionately targeted in very discriminatory ways in our immigration laws for a very long time. So maybe that requires then disproportionate opportunities for Haitians who want to emigrate to do so, disproportionate efforts to reunite people who've been deported to Haiti from families and communities here, and ultimately damages, reparations. I don't know that you can litigate for a Truth and Reconciliation Commission or something like that, but if we think there's a restorative justice process that's required, could that be imagined as well? These are very tentative and obviously big thoughts, not fleshed out at all.
Great, thank you so much. We're entering the last couple minutes of the panel. I want to repeat the CLE code for all of you wanting to get your CLE. It is the color purple. So that's purple for anyone who doesn't have it yet. And then I want to lift up one very last question as we close the panel, and just huge gratitude to the panelists for their work and for their reimagining of how we can all use race in our cases in a way that matches the lived experiences of our clients and all of us. So I love this question because it packs a punch in a very few words. How can one push for an anti-racist framework within a very racist immigration and legal system? So I'll invite the panelists to weigh in on that and any closing thoughts before we turn it back over to Raymond.
I think we have no choice but to try. We have to keep telling the stories of our clients' lives and their experiences as they and we understand them, and with no illusion about immediate change, certainly among certain judges or others in the court systems who have particular perspectives. Nevertheless, I see the Keep Hope Alive comments in the thread as well, and despite the challenges, I retain that hope. My clients, like yours, are hopeful themselves, and bold and risk-taking and creative. And I think lawyers must honor that boldness with boldness of their own.
Yeah, I'll just echo that, that the struggle is long, and that people have been fighting before there were these impact litigation strategies, and will be fighting after, if we don't succeed in these cases. And so I think, it's important to continue to be creative about all the possible tools that we can use in litigation and other advocacy to support and lift up the stories of our clients and community organizations. But that also we have to be very cognizant of the ways in which courts might not be the best forum for pushing an anti-racist platform or anti-racist policy, and be very clear about the utility of litigation in and of itself, and the utility of litigation in advancing community demands and telling stories, and where litigation is not useful, and where we might instead seek to limit the intervention of courts or limit the intervention of the state, rather than pushing for any particular active action on behalf of the courts or action on behalf of the state. I'll say that type of tactic has been effective for us on the state court level more than it has been on the federal court level, but really wresting control out of the hands of the court and out of the hands of the government, and putting it into the hands of the community where you're trying to build power, I think probably is a longer term strategy for how people might build a real anti-racist vision for themselves.
And building off of Mike's and Oren's points, it is, it's important to keep on fighting. It's important to recognize that litigation is not the only solution, and that there are various forms of advocacy that also has a critical role in combating anti-Blackness in the immigration space. And the fact that we need to be creative with how we think about legal strategies, and thinking about whether it makes sense to heavily rely on federal courts, or looking at state courts, looking at local legislation, state level legislation. I think all of these have roles to play, and I think as lawyers we need to keep coming up with creative strategies and think about how we can present compelling equal protection arguments in a way that would resonate with judges who may be more hesitant to find in favor of a plaintiff with an equal protection claim. And so, I think I'll leave it at that for, those of you who are starting your legal careers to, just maintain that fighting spirit, and to, really, think about creative solutions, and to work closely with these inspiring community organizations and community members who are continuing to fight and will continue to do so, and how it's important for us to take the lead from them.
Beautiful. Thank you so much for your eloquence to the panel. I am going to close this panel in a way the first panel began, which is to finding hope in dissents. So there was much discussion about Justice Marshall's dissent in the Jean B. Nelson case. And for myself, I would say, though she was alone, I found hope in Justice Sotomayor's dissent in the Daca case. She said three important things when she chastised her colleagues for dismissing the equal protection claim. She said first that it was wrong to discount Trump's myriad racist comments about Mexican immigrants as people who have lots of problems, the bad ones, criminals, drug dealers, and rapists, and his comparison of immigrants to animals. She said, taken together, the words of the president helped create the strong perception that the rescission decision was contaminated by impermissible discriminatory ends. She wrote that she would not so readily dismiss the allegation that an executive decision that disproportionately harms the same racial group the president has branded as less desirable mere months earlier. Those words resonated with our plaintiffs. Those words sat with their lived experiences and the way they have experienced the last 4 years as immigrants, as people of color, and as folks who've been targeted by this administration. So I bookend this panel with our prior panel of where we can look for creative solutions in the words of the lone justice and dissent, and turn it over to Raymond. Thank you so much.
Thank you so much, Karen. And a huge thanks to Maryam, and to Oren, and to Mike, and to Moose, and to Ira, and to Ninaj, and to Erwin for this rich and nuanced and urgent and imaginative discussion.